Welcome to our Savvy series. I'm Catherine Magana here with Rachel Ivanovich. And today we're going to have a discussion on, is your estate plan ready for 2026? I can't believe we're already talking about next year. And I know Rachel just is still, she's finally in 2025 here.
Exactly.
But we want to welcome you to join us today. And one of the things earlier that took place was the One Big Beautiful Bill Act signed. And with that came some changes in the estate planning and some of the exemptions. And so we wanted to have a little discussion about the importance of, trust and estate planning. And obviously we collaborate with an estate planning attorney. We actually have a few references, and one in particular, Geeta Nasiri from Capital Legacy Law, is somebody that we've worked with periodically.
She'll be doing a webinar with us.
She's doing a webinar, yeah. So we have a webinar coming up on December 4th. Where we're going to be talking about estate planning a little more in detail. But we thought we'd scratch the surface since it's kind of the end of the year and kind of thinking about what's a good kind of planning things to be thinking about. And so for 2025, as we're kind of wrapping up this year, the exclusion amount is $13.99 million, call it $14 million per person. So that was obviously something that was in place for 2025. And then it looks like for 2026, the exclusion amount goes up to $15 million per person. And so that when it comes into play, sometimes people think, okay, what does that mean? And I think one of the things that we find is in 2025, which is this year, you can gift up to $19,000 per person without having to do a gift tax return. But Rachel, you do taxes and all that. Do you want to share
break this down a little bit. And as you just said, I am finally in 2025.
Yes.
The 2024 filing season is finally over. Hallelujah.
Yes. Nice.
But so if you've been waiting for certainty, the One Big Beautiful Bill Act, what finally enacted in July, now we can plan. So this new law doesn't really. Let's break it down into what's an exemption and what's an exclusion, because gift tax law and estate law is really complex. So if you don't understand it, just bear with us here. We'll break it down for you. Okay, so you have what's called a lifetime exclusion. So basically what that means is tax is a certainty. You're going to pay them while you're alive, and they want to tax you when you pass away. But you can exclude up to, like Catherine just said, up to $15 million starting this next year. So that's really accumulate up to the 15 million mark, but there's an exemption amount as well. So what that means is you can gift any one individual up to $19,000 in this year, and if you're married, your spouse can also gift that same person that amount. So that $19,000 isn't included in that $15 million figure.
Okay. But you don't have to do a gift tax return if you are within those
Correct.
guidelines.
And it gets really complicated, and I just actually filed 4 gift tax returns yesterday. So what that basically means, so if you gift somebody, any one individual under $19,000. Sorry, I'm a little tired from yesterday. You don't have to file any paperwork. You can just write them the check. You can transfer the money. You can give them cash up to $19,000. If you give more than that, property or cash. So, for instance, if you gift somebody your car and it's worth more than that $19,000, then you may also have to file a gift tax return. And when you file a gift tax return, it doesn't necessarily mean that you're going to be paying tax with that return. It just means you're carving into that lifetime exclusion. So you're going to exclude from your estate who processes your estate will not have to pay tax on that amount.
Well, and it's interesting. I know you've mentioned it, but often sometimes we'll have clients ask, okay, so if I give $100,000 for a down payment on a house, then yes, that would be part of this.
And
then they ask, well, do I have to pay taxes?
Correct.
Again, even though you said it is.
And that was almost exactly the scenario, except it was a little different. So I had a couple, husband and wife, they gifted the parents $100,000 because they decided to all move in together and they wanted to just pay off the mortgage. So they gifted mom and dad $100,000, and so we ended up filing 4 gift tax returns. And the reason is being husband to dad, husband to mom, and then wife to dad and wife to mom. And so they each got the for 2024 it was $18,000 exemption. So instead of, we wanted to make sure that they got all of those exemptions, so that's why we filed 4. And so it was $25,000 gift to wife to mom, wife to dad, so 25 and 25. But that actually only, the reportable amount on the gift tax return was only $7,000 per person. And so it's a little tricky, but we were trying to preserve that full lifetime exclusion for both of them. And just it was a little more paperwork.
Yeah. Okay, so we often, as we're doing financial plans with our clients, we have conversations about when was the last time you reviewed your will or your trust? Do you have your power of attorneys in place for health and financial? Or there's also times where potentially you do not have a trust or anything in place. And occasionally what we find is there are some clients that perhaps remarry, and so they have multiple families, and then there's a little more to it and planning involved, and so it's not uncommon where sometimes you get stuck or you don't know where to go, and that's where an estate planning attorney can come in and really kind of make sure your trust is set up the way that you want, because there might be some other money tied from previous marriages and kids, and so that's one area we do see, but working with an estate planning attorney I think is really important. And then we also have clients that haven't reviewed their trust in a while, and they know they need to, and part of it is also the guardianship. Some of those things are in place.
Absolutely.
And things change. So sometimes maybe you put something in place now and that might change over time, or perhaps the executor or some of the beneficiaries, maybe things happen in life. So you definitely want to meet with your estate planning attorney. We review it to make sure, okay, is there anything that stands out to us? But we're not the experts in that area, but we know enough to help you with your financial plan and make sure that some of your estate's in order. Another item that comes up that we find is the titling of accounts and properties. So as we're having conversations, we typically will ask to make sure that are things titled properly. And believe it or not, it's not uncommon where we find out that there might be some either checking or savings or investment accounts that aren't titled properly, or a property or house or something that isn't in the titled in the name of the trust, even though it's listed in the trust. That doesn't mean it's part of the trust unless it's titled. So those are some things usually the estate planning works with, and sometimes they give you a list of things to go off and do on yourself. But those are definitely some things that we, as we're looking at with some of our new clients, making sure that those items are in place.
And as I think you just mentioned something about making sure that you have a trust in place, because you want to avoid, and the reason to have the trust is to avoid probate.
Oh yeah, that's a big nightmare.
It can be a big nightmare, and so depending on the state that you live in, there are different laws, but. You want to make sure that, like you said, all the assets are in the trust, but I think that going back to talking about that exclusion and the exemptions again, I think it's really important to, if you do have high net worth, and in states like California where real estate is worth a lot of money, you can get to that $15 million figure, which is next year's, pretty quick, especially if you own several pieces of real estate. And so if you do have assets in brokerage accounts and also real estate, make sure that you're counting everything when you're looking, because we're throwing out this $15 million figure and people are thinking, well, maybe I'm not even close. But guess what?
When you start eating the equity and the properties.
If you start looking at the price of your real estate, that can add up really quickly. And so a lot of people don't even know that some states have laws when you pass away that you have to pay tax in the states. California is not one of them. So you want to make sure, depending on what state you live in, that you check on the laws because those taxes might apply as well. So make sure that we are coming to the close of the year. You still have time to make gifts and use your exemption.
Well, speaking of gifts, there are, once again, depending on your state, there are different things you can set up. There's also donor advised funds and some other types of...
There's all sorts of fun things that we were researching.
Yes, and so there's also, if you own a business, there's different ways to structure the ownership and how you're getting paid out. And so there are some planning techniques. Obviously, we will collaborate with your estate planning attorney and making sure that if you are charitable, that there's some different things that you can put in place.
Yeah, there are things called CRUTs and CLTs. I'm sure a lot of people have heard of donor-advised funds that are not only for philanthropy, but also to reduce your taxable base of your estate. So if you are interested in any of those, the charitable remainder unitrust, that's a CRUT or a charitable lead trust. We can talk about those if you're interested in how to reduce your overall taxable estate.
So once again, as we do financial planning and we do weave in the estate planning part of it, and we're happy to help you look at your individual situation. And we hope you learned something new today. And we definitely, as we're kind of approaching the end of the year, want to make sure that your estate's in order. Collaborate with us. Talk to your estate planning attorney. If you need a recommendation, we're happy to give that to you.
And if you haven't yet revisited your plan the last few years, it's time. Give us a call. We'd love to chat with you.
Well, and especially with all the tax changes and everything,
there
too.
are going to be
there's
a lot of
been
new ones this coming
there's been
year.
A lot of change. So, so if you'd like to set up a complimentary strategy session, you can reach us at 760-692-5700. Once again, that's 760-692-5700. And thank you for getting savvy about your finances with us today. And remember to savvy up. Please stay tuned for important disclosures. The opinions expressed in this program are for general informational purposes only and are not intended to provide specific advice or recommendations for any individual or any specific security. It is only intended to provide education about the financial industry. To determine which investments may be appropriate for you, consult your financial advisor prior to investing. Any past performance discussed during this program is no guarantee of future results, and the indices referenced for comparison are unmanaged and cannot be invested into directly. As always, please remember investing involves risk and possible loss of principal capital. Please seek advice from a licensed professional. Savvy Woman Wealth Management is a registered investment advisor with the SEC.